Curious about a case that could wreck your workplace? Lucky for you, we have a lawyer on the clock.
So, Phil, we've been talking a lot about the new Missouri paid sick leave law. Just to remind all of our listeners that this new law, which was passed during the last election, so it was a ballot initiative, the law goes into effect, or the paid sick leave is available for accrual and use starting May 1 of this year. The first significant date is actually April 15. That's the date that employers have to post notices informing employees about their rights under the Missouri paid sick leave law. As we mentioned before on the program, and as I mentioned during our separate program that we did just on this law, simulcast program we did at your offices at AIM, there has been a challenge filed directly at the Missouri Supreme Court challenging this new law.
And we had the attorney on the program. I think on one of the days you were out traveling, and talked a little bit about that challenge. So that's something, if you're interested, someone can go back and look at that program to understand this challenge and reasoning.
Yeah.
Go ahead.
So oral argument on that is scheduled for March 12th next month, so coming up in a couple of weeks. Last week, the petitioner, the lawyer representing the people who are challenging the law, your guest you had on, they filed their brief at the Missouri Supreme Court. And the other side, I think, is due to respond to that. I think it's next week, and then again the oral argument will be on March 12th. And so basically, in their brief, they're saying that the law should, or the Missouri Supreme Court should set aside the law because Proposition A's fiscal note summary was insufficient and unfair, in that it failed to identify the costs to local government and private entities, as the fiscal note summary does not state the costs submitted by Clay County, Missouri, and the private impact stated by the Missouri Budget Project. So that's the first avenue of challenge. The second avenue of challenge is that the Supreme Court should set aside Proposition A because of the summary statement for Proposition A, and that's what was provided on the ballot, was insufficient and unfair, and that it failed to give voters notice of what Proposition A would accomplish, as it lists existing provisions of law which are not amended, and failed to state key provisions of Proposition A such that it constitutes an election irregularity. And what they're really getting at on this one is that people thought that they were voting on just minimum wage, and they didn't realize that they were voting on a Missouri paid sick leave law. And then finally,
and that's what I've heard most people in conversation express to me. Most Missourians that have shared their expression saying, well, I did or I didn't vote on that because of their position on minimum wage. Very few people, I think, were voting with paid sick leave in mind.
Yeah. Well, and then the third point is that they're arguing is that Proposition A violates what's called the single subject requirement of Article 3, Section 50 of the Missouri Constitution, because it has two separate and distinct subjects, and that the increase in the minimum wage and the newly created sick leave law are not a single subject, but instead two separate subjects. And so I think that one's really got some teeth to it. And then their final point that they rely upon is that Proposition A is invalid because it also violates the Missouri Constitution, because it fails to give notice of the single subject of Proposition A by listing a number of unrelated matters contained therein. So it's kind of the converse of the immediately preceding argument. So I think those constitutional challenges have some real teeth to them, and we'll have to see what ends up happening here.
So I heard you in the pre-show, you were talking about how you will be watching this. So, I mean, I'm not want to call you a little nerdy or geeky, Bert, or something like that. Wouldn't really be professional of me, but people who have a
Hey,
deep interest in this
Phil,
space,
Phil, if
just,
that's the worst thing I get called today, I'll be fine with that.
yeah, absolutely. So, but this is something that is going to be broadcast.
It is.
Yeah.
The Missouri Supreme Court oral arguments are broadcast live. If you go to the Missouri Supreme Court website, you can listen to oral arguments live, or you can listen to recorded oral arguments. If anybody wanted to go back and listen to my oral argument where I prevailed 6-0 in front of the Missouri Supreme Court about a year ago,
But you
you're
did.
welcome to do that.
Not everybody can claim that. That's right.
That's right. So yeah, it will be broadcast, and I will be listening diligently because, in particular, I'll be listening to the judge's questions of the attorneys, because I think through that we might be able to glean a little insight as to which way they're leaning on this law.
All right. Well, let me just wrap this up with a few points, because you and I did a simulcast program for those employers that were going to be impacted by this back in November. And we did it in two parts because we knew first we needed to come out early with some information as we were moving into the close of the year, and businesses were trying to establish budgets, and some things that are affected by this law, like our IT systems, may need to be adjusted, and those things just don't happen overnight. So we had an early session in December, and we had a great turnout simulcast, both in person and online. And we announced it as two parts. We would have a part in December, and later in the first quarter of 2025 that we would have part two. And if you attended part one, you would get part two complimentary. So since then, we've had more people interested in attending and learning more as the date for implementation draws near. And so here's how that works for anyone that's interested in attending. If you are still interested and you did not attend part one, you can purchase the program and you can go back and watch the recording of part one. And then you would be also given the access code to participate live, whether online or in person, for part two. And Bert, I can tell you that there's been a lot more people sign up now that we're getting closer, and you get to that oh heck phase of this is going to really happen. And so what people are saying is, well, do I really need to be worried until this lawsuit, or this, I don't know, what do you call it when this challenge is just determined?
Yeah.
And I think that answer is yes, right? Because our part two program will be on March 20th, and we pushed that as far after the oral arguments as we could, so we can get a feeling for that. But hopefully with enough time to make the necessary adjustments, assuming this passes. And what you and I were talking about is, it won't be a decision of, yes, it works, but you have to change the rules to how it works. It either is upheld or denied, and it will probably go through as it was defined. So the things that we're talking about, if it does go through, would still all apply.
Yeah, so the Supreme Court will decide whether the law is valid or invalid.
Those are the words I was looking for.
Yeah, if it's valid, the law as it was passed back in November will go into effect. Again, April 15, notices need to be posted, and May 1, people can start accruing and using their leave. And so, yeah, that it goes into effect as is if the Supreme Court upholds it. If the Supreme Court rejects it, decides it's invalid, then it gets thrown out. Now, there is one other development, and this one won't take long to share. Missouri House Bill number 567, which I think was proposed late last week and is making its way through the Missouri General Assembly. They proposed modifying the law such that it takes effect. Employees would begin to accrue leave January 1, 2026, with the notice posting of December 15, 2025. So basically extending the implementation of the law by another 7 months. As far as I can tell, I don't think there were any other proposed changes in this House bill.
Okay.
But it's just interesting that they have put those dates past the next election, and also to give employers more time to be able to comply, and also probably for additional challenges to work their way through. So
Yeah.
I'm not quite sure of the timing on the passage of this, but there is another avenue of attack taking place simultaneously.
So I don't know if that will happen because that's awful logical. So I'm not sure if we're gonna see that type of logic play out, but I hope we do,
Yes.
because it's complicated to start these types of accrual programs that already align with your other paid leave programs in the middle of the year in any cycle, right? It's much easier from a management standpoint, not just technology. That's probably easier to do mid system, but from a PTO, vacation, sick days, from those types of leave programs, you kind of start them and then you got to reset them in May, and that's kind of complicated. So for no other reason than giving our employers a chance to get on this and do it right from the beginning, I hope that part of it happens.
Yeah. Yep.
Thanks for being an on-demand viewer of This Week at Work. Don't forget you can be part of the show by watching live at 7:30 a.m. Central every Thursday morning, when you can get your burning questions answered by using the question mark icon to the right of the player. In fact, you can ask a question now. Head over to aimea.org. Under Member Resources, you'll find This Week at Work. Click Listen Live to register for our next episode and submit a question. Or follow or subscribe wherever you get your news and entertainment. We'll see you next week when we discuss what's happening this week at work.